Hi, everyone. Hi. Thank you so much for coming tonight. My name is Amanda, and this is Claire, and we're the organizers of ArtsTech. So for those of you who are new, welcome. For those of you who've been here before, thank you again for coming. So tonight we have a very special event where we are going to be discussing art law and copyright. First, before we begin, I want to thank our volunteers. Mitch and Roxanne are here tonight, and they are wonderful, and Mitch is doing the live stream. So we'll be live streaming the event tonight. Thank you to Spotify for hosting us and their beautiful, beautiful space. And what else should we talk about? I guess we can get into bios and introduce the speakers. And if you want to, tweet during the event or follow what's going on, you can check us out at ArtsTech Meetup, and our hashtag is ArtsTech. So,
all right, great. So quickly, we'll do the bios of our 3 speakers and our moderator. So first, we have Kevin McCoy. Kevin's at the end there. He is an artist and NYU professor. In 2014, he created Monegraph, an online platform for media licensing and attribution. He is the company's co-founder and artist CEO. He's worked for more than 20 years at the intersection of art and technology, and his art is in the collections of the Met, MoMA, and the Whitney. Judith is sitting next to Kevin. Judith is an attorney, mediator, and arbitrator focused on art law, copyright, entertainment, and commercial law. She's the former chair of the Entertainment, Arts, and Sports Law section of the New York State Bar Association, and is the chair of the section's Committee on Fine Arts, and co-founder and co-chair of the Committee on Alternative Dispute Resolution. In addition, she's a member of the Art Law Committee of the New York City Bar Association, and she served on the Copyright and Literary Property and Entertainment Law Committees. She's a frequent lecturer on art law and is a leader in the intellectual property field. Franklin, right behind me. Franklin Boyd is an arts attorney with a general commercial practice. She's the founder of Zipsy, thank you, and home of the negotiated resale right for artists. She teaches art finance, market, and law courses at Sotheby's Institute of Art, and has served on the boards of Art in General, 01, correct, and Smart Spaces. And Sean Fader, last but not least. Sean received his MFA from the School of the Art Institute of Chicago, his MA from the Maryland Institute College of Art in Baltimore, and his BFA from the New School in New York City. His work has been exhibited throughout the U.S. and internationally in Dubai, Canada, Mexico, and England. He was named an NYFA Fellow in 2013 and a Blade of Grass Fellow for 2012 to 2013, and received Magenta Foundation's Flash Forward Award for Emerging Photographers in 2012. So very accomplished panelist here with us tonight, and without further ado, I'll pass it over to Kevin and we'll get going.
Thank you. I thought that we would start. Judith has prepared a really great deck with images that cover some initial historical points and set the discussion into a broader context, and then also goes into the relevant, some relevant legal terms like fair use, which is a really critical concept. So I thought that she would speak a little bit about these initially to kind of get us going. And I also wanted to point out that she also is a professor at Sotheby's, and she has a great new book that just came out on visual art and the law, and you should check it out. It's really good. Would you like to stay here, and I will be there and drive it, or do you want to drive it yourself from the podium? Okay. You have to hold this though.
Great. Welcome everybody. This is an exciting panel, and I'm very pleased to share the stage with my fellow panelists. I thought I would start out by saying that appropriation is not a new phenomenon. In fact, it's very basic in the creation of artworks. I'm going to give you some examples of appropriation throughout art history. Pablo Picasso stated, "Good artists copy, great artists steal." And this theme has been repeated in other art forms as well. T.S. Eliot said, "Immature poets imitate, mature poets steal." Igor Stravinsky said, "A good composer does not imitate, he steals." And Steve Jobs quoted Picasso and stated that, "And we have always been shameless about stealing great ideas." So there is nothing new about appropriation, and what is new is the digital platform where works are appropriated. So let's take a look at the Baroque and Picasso. They worked with each other. They sometimes couldn't even tell their own works from each other's. Another example of Picasso with the Lichtenstein to the right, riffing off Picasso. Everybody knows this image, of course, and the Marcel Duchamp, very famous Elle lâche au cul, which is a, if you know French, you know what that means. It's and this is another example. Another example of Velázquez on the left and Picasso again on the right. This very famous painting of Manet, Le Déjeuner sur l'herbe. Everybody knows this painting, and what you may not realize is that he borrowed the setting from the lower right-hand corner by Raimondi. And Picasso also did a rendition of this piece. This very famous piece of Manet, Olympia, from 1863. Manet loved to look at the works of the great masters and looked at Goya, for example. This is a theme, the Sleeping Venus, throughout art history. Titian and Giorgione as well, with Titian painting in the background. In the more modern days, we have reef photography with Walker Evans being rephotographed by Sherry Levine. And a reappropriation of ready-made. Marcel Duchamp's famous fountain, which is considered by some critics to be the most important work in art history in the 20th century, and Sherry Levine on the right. And of course, no talk would be complete without mentioning Andy Warhol, who borrowed from Campbell's Soup, and then there was a dress made as well in this motif. Here's an example of Doug Aikens using a trademark to create a work of art. So, what is fair use? Fair use is an affirmative defense against an action of copyright infringement. It protects the public's access for purposes of criticism, comment, reporting, teaching, scholarship, or research. That's why I was able to download the images I just showed you, because I'm commenting on them. Fair use allows others to use copyrighted material without the owner's consent in a reasonable manner for certain purposes. In determining whether the use made of a work in any particular case is fair use, courts are required to weigh what is called the 4 fair use factors. And these are as follows: the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. In recent years, the first fair use factor has become the most important factor, and courts look at whether the use is transformative. So you will see that language, transformative, in every fair use decision that comes before a court. The nature of the copyrighted work, that is whether it's been published or not, whether it's fiction or nonfiction. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. There is no bright line rule in the United States for how much you can take. There's no percentage. So it's really based on a case-by-case analysis. And then fourth, the effect of the use upon the potential market for or value of the copyrighted work. This used to be the most important factor because it weighs the market harm, whether the second user is substituting the work of the first artist. But these days, in most jurisdictions, the most important question is the first fair use factor, transformativeness. And if the more transformative a work is, the less important the other factors are. So I think that maybe I could stop there, and I'll turn this back over to you.
Definitely. And I think that I would like to have Sean talk about his experiences this past year with at Gagosian Gallery, and I think that can kind of be some just additional context that brings it up to the present day.
Is this on? I do. Yeah. So I guess my sort of role here is the artist who both was appropriated and then in turn appropriated back. So I don't know how many of you guys did a lot of you guys see the Gagosian Richard Prince show Instagram images? So I think it's 2 years ago, I did a performance piece called #WishingPelt, in which I invited people to enter a room, whisper a wish in my ear, run their hands through my chest hair, and then to seal their wish, they would post a photograph on Instagram with a #WishingPelt, and the expression was the #sealed your wish. And there's lots of reasons why this piece happened, and we'll just sort of skip that part for now. So during the period of time, this girl, Kara, and some friends came to make a wish. They posted on Instagram, and then pretty soon afterwards, Richard Prince commented on the bottom of it, "The fight for Earth doesn't end until one of us is gone, period, TNT, period." I have searched, and I have no idea what that actually means, other than we argue whether it's explosive devices or Turner Network television, which is, I think it's the latter, but it's just my personal opinion. I didn't sort of understand what that all was at the time, and then 9 months later, Richard Prince opened a show at Gagosian, and this was the feature image of the show, and I immediately started getting emails from everyone. Do you know that there's a giant 6-foot photograph of your face in Gagosian? Which the answer was no. It was sort of not totally surprising to me because I had sort of known that he was doing something, but I didn't actually expect to end up in the show, which was, I think there was 25, you saw it too, 25-ish pieces, maybe a little bit more. And so this was sort of in the middle of all of them. My response was, this is really weird, and actually I ended up meeting Franklin as a result of it, who agreed to talk to me about the situation. Long story short, I decided not to sue or pursue any sort of legal route. I decided instead to send out a press release that said, go see my work at Gagosian in a show organized by Richard Prince, and wrote a really extensive press release in which it described my relationship with Richard Prince and why he had chosen to put my work in a show that he had curated. And so then I was immediately asked to be in a show about artists that steal from each other. And so I ended up getting the strangest text message right before the show opened. I had no idea what I was going to put in the show, and it was 4 weeks before the show, and I kept freaking out, right? That, like, I just got asked to be in a show, and I'm supposed to put a thing in the show, and I don't know what it is, because I keep changing my mind. And I got this text message, "Hey, Sean, just thought I'd introduce myself. I'm the collector that bought your piece from Gagosian. I read your press release. I just thought you might want to borrow it for a show." So I sort of sat there, I sort of sat there confused, right, in that moment as I'm staring at this text message. And so what I ended up putting in the show is this piece in which I reappropriate the original piece, and then I added a second panel to it. And the second panel says, "Our pictures are for each other, #wishingpelt," because that's the original piece. #collective authorship, because I started thinking a lot about the original piece and in terms of collective authorship and what it means to author somewhat of a meme in a digital space, right? And #ArtSelfie. And there's a selfie stick actually on the floor. So this piece is, you're meant to stand in front of it and take an art selfie with it and send it back to Instagram from where he stole it. So it's this sort of cyclical piece that sort of comments on it, and it's Inkjet on canvas plus selfie stick is the materials list. So it became this sort of like cyclical conversation about this piece. The piece is actually called Backdrop for the Rebirth of the Collective Author, in reference to the death of the author. And then in parentheses it says, quote, "There's a whole lot of authorship going on," and close quote, Richard Prince, which, so I quote him and I credit him for that quote in the title of the piece. You know, little jab. So it became this sort of like other piece, and that sort of had a life of its own in Instagram and sort of commented on the sort of reappropriation part of the whole thing. And then Richard Prince sent out this tweet that said, "Your pictures are for each other. Yes, that's true. My pictures, ? They're not mine. Never were. Vampire." I thought the whole thing was hilarious, so I just commented, "Thanks for the mention. #vampire problems" is actually what I wrote, which I don't think he got. So that's sort of the story of the my relationship to appropriation and sort of that sort of like back and forth conversation that I sort of had publicly with Richard Prince.
Thank you for that. The Richard Prince story continues because apparently, in regard, from this about this panel tonight, he sent out this tweet saying this: "I don't appropriate." I mean, funnily enough, I'm good friends with Richard Prince's studio manager, and I'm sure he oversaw the printing of those photos. I'm sure he did. And then I wanted to just as to round out the introduction. Franklin had put together some slides about terms of service and specifically about Instagram, and I thought that it might be good just to talk about that as well, just to kind of set the context in this particular case with Instagram.
Sure. So I had thought that we would potentially even incorporate these as we're speaking this evening, but happy to kind of jump through them. And this really comes out of a conversation that we had prior to the panel this evening, which is, well, what are the legal obligations? What is the legal context that people are operating in under Instagram? Because I think a lot of people don't really know and they don't really think about it, right? And I know that, Sean, you had called Instagram or reached out to them. I guess you probably emailed them, right? You probably didn't call them. Okay. Okay, so he used a family connection the old-fashioned way. But Instagram is very clear, right? So if you post something as user content, you still own it, right? It's entirely your own. It's your own work. And then what you're giving to Instagram, what you're granting to them, is a non-exclusive, fully paid, but what it is it's transferable, sub-licensable, worldwide license to use the content, right? So that's kind of point one, is that once you put it up there, you have licensed it to Instagram. And then the more interesting thing, which of course it's all written by lawyers, and so it's extremely kind of nimbly-pimbly, which is that Instagram is not responsible or liable for the conduct of any user. They essentially always straddle two lines, which is that they can kick somebody off if they want to but they have absolutely no obligation to do so, right? So if you are somebody who they decide is somehow breaking their community guidelines, they can shut down your Instagram account. But if you're somebody who's complaining about a third party that's doing that, they aren't obligated to act upon your complaint, right? So they're kind of having their cake and eating it too in that way. But as if I were Instagram's attorney, that's exactly how I would write this. So I can't fault them in this way at all, right? But very specifically, right, they have no obligation to block or edit. And essentially what they're saying is we're not acting as the police for anybody else's behavior on Instagram. If, however, you believe that there is infringement going on, you can write to them with an infringement claim, and then they are actually obligated to take a couple of steps. And they have this obligation to insulate themselves.
Is this because of the DMCA?
Yes.
Okay.
Yeah, exactly. Hello. So what they say they'll do is, and again, the language is all very, it's a little bit loose in terms of the responsibilities that they're putting on themselves, because they're saying it may result in removing the reported content. And what they'll do is they will essentially reach out to that third party. If you say, hey, Sean is stealing my content, they say, okay, all right, we're going to get in touch with Sean, and we're going to let him know, and maybe even in advance, we'll remove the content that you're complaining about. But we're also going to give him an opportunity to come back and say, no, that person's crazy. It's absolutely my content, right? And they will provide Sean with my contact information. And in a certain way, Instagram even seems to be encouraging people to kind of work it out on their own, right? Like, hey, we'd really like it if you don't bother us so much with this. That would be great. Everybody play nice. And then this is where they're essentially saying, all right, if you're a repeat infringer, we will disable your account when appropriate, right? So they still give themselves that wiggle room. So they're never actually saying that we will definitely do something. Again, repeated infringement will disable when appropriate. And then I think we just probably have the DMCA, which was just referenced. For those of you who don't know what the DMCA is, it gets tossed around a lot as the acronym, like everybody knows the DMCA. So it's the Digital Millennium Copyright Act. And really what it was, well, there's several provisions in it, but the key one for most people's purposes is that it gave liability protection to websites and internet service providers. Because for a while there was that question of, is YouTube responsible for all of the infringing content that's uploaded, right? Is Google responsible? Are these people? And they were like, how can we possibly monitor all of this? So this system was put in place such that if somebody believes that their copyrighted material has been put up online, they are supposed to contact the either website or internet service provider and then go through this process of having it taken down. So, when you're searching for that Portlandia clip that you saw 3 weeks ago, and then it's like, sorry, it's been removed, it's because they got a DMCA takedown notice, and now it's been taken down. So that kind of sets the stage for that.
Yeah, that's great. Let me see. I'm making this up on the fly a little bit. I thought it would be an interesting. Just in this context alone, it's interesting to show this piece of mine. My wife and I, the piece that's in the Metropolitan Museum of Art collection from a long time ago, because it's kind of strangely relevant. It's from 2001, called Every Shot, Every Episode, in which we make a video database of 20 hours of the original Starsky and Hutch TV series, in which we break up that material in a shot-by-shot basis and then reorganize it into these descriptive categories that we put onto video CD. This was before you could record DVDs very effectively. So we have 278 video CDs in which these video things have been just left kind of on a cut-by-cut basis and reorganized to be every boss, every laugh, every explosion, every cry for help, every van, and so on, with the original labels designed to look like the generic food labels that we remembered in the 70s as kids. So rampantly ripping off, copying, wholesale as many hours of this TV show that we could, and doing nothing to them except changing the order around in this kind of in this way. The people in the Met wrote a nice description about it, kind of putting a nice historical context to it. But at the time we were making it, we were just thinking, is this just, are we going to get sued?
Did you get a letter?
Never did. So it was moot. But we made a bunch of work at that time period that was about these kind of found database concept of from film and TV, and made a whole bunch of works like this, and then got sick of talking about copyright and changed the work that we were doing. But I thought I'd bring that up just because it's relevant to the discussion that's going on. And so I guess the question is where, and you had mentioned this earlier, but there's kind of lurking above all of this is a First Amendment question, right? That's kind of guiding all of it, and then copyright, which is an attempt to provide for a period of time some kind of monopoly value on intellectual property, that has some connection. I mean, patent is a similar kind of concept in a related way, although for a much shorter period of time. But just that balance between First Amendment, which is the sort of ultimate right in our country, versus this idea of commercial monopoly that's being balanced. And how does that change? Does it change in the digital, through the process of digitization, or is it still the same kind of fundamental struggle?
Well, I think it's it's a new context. I mean, I think that when our founding fathers drafted the Constitution, they weren't thinking of the internet, but I think that it's very much it's very exponential. It's so easy to find works on the internet and transform them, upload them, and manipulate them. So I think that this is really magnified in the current era. But as I showed, as I showed earlier, artists have been doing this since the beginning of time, and it's just much easier. And in fact, you also have to consider that the art form has also changed. I mean, some art is not even visual at all. So artists, what are they're taking, but maybe that's part of what their art is about, is the appropriation. And certainly we see that in the Sherry Levine or in Richard Prince, when his rephotography of the Marlboro Man, and there are many such examples.
All right, so I'll bite and say that we are in an incredibly different, brave new world. And if anybody actually wants interesting legal reading, I recommend the Google amicus brief in the Richard Prince Carew case. Why did Google feel the need to write an amicus brief where they were like, oh, and by the way, we don't really care who wins? Actually, they were very specific about that. We don't actually care about this case. What we care about is that, and this was to the appellate court, what they were really concerned about was the decision at the district court level, which most people agree was a pretty bad decision. Because what the judge did there was she said, Richard Prince's work is not transformative because it does not comment on Patrick Carew's photographs, right? And she really focused on the idea.
Could you give a brief background on what that is? Because it's separate from this Richard Prince story.
Oh, yeah, sorry. For some reason, I have this assumption that everybody reads as much about this as I do. Right. So we're going to get some images here really quickly. But obviously it's so funny to have Richard Prince be like, I don't appropriate, even though most people would say he is literally the poster boy for appropriation. I don't know. So Patrick Carew had lived among Rastamen for several years, I believe, and then ultimately published this book of classical photography called Yes, Rasta. And then Richard Prince saw the book in a bookstore in St. Bart's, bought a couple copies, and ultimately started ripping pages out, collaging them onto canvases, and then also blowing up the photographs themselves and using them as source material for 30 paintings, which were later shown at various Gagosian locations. Patrick Carew brought a lawsuit against Richard Prince, and initially the district court held that these were absolutely infringing works. The works that hadn't been sold, she ordered impounded and destroyed, along with all the exhibition catalogs that had not yet been sold, were to be turned over and destroyed. So obviously Richard Prince appealed. And that's where we get this Google amicus brief. And the case itself is really interesting, and I'm sure Judith can weigh in on a lot of the art aspects to it as well. But what we're seeing now is that fair use is being driven in a couple of different directions, because there's certainly the art direction where it's, okay, transformative because there's a new aesthetic, or there's, again, this idea of commenting on works. And the district court had really focused in on simply the idea that it had to comment or refer to or criticize the underlying work, right? So there had to be this real sense of relationship between the two. And which is, as sort of an aside, why I personally think that the Richard Prince Instagram works, he went out of his way to comment on each one as a sort of giant bat to the district court, where he's like, oh, I'm sorry, you want to comment? And he's even said that he made all of his comments were nonsensical, right? He's like, I didn't mean anything, I was just posting a comment. And you're like, yes, Judge Bats. But Google here was very insistent that the Second Circuit overrule this idea that there had to be comment or criticism on the underlying work. And they even are sort of going a step further and saying, we need to maybe get rid of this word transformative and really focus on the word purpose. And does the copying serve a different purpose? And this is important because for them and several other people, there's this idea of copy-reliant technologies. You can't have a search engine, you can't have caching of images, you can't have image search, right, without actual copying of the images. Nobody's commenting on them, they're not criticizing them, there's no art historical reference. And this becomes an incredibly different way of looking at the world, is this idea that we have copy-reliant technology that because it serves a different purpose, it's fine and therefore it's fair use. And to bring it back into the art context, what I'm really seeing then is that each artist is actually obviously feeding the content that is being searched and cached and advertising is sold against, and that is the business model of these copy-reliant technology providers. So that's why I think that we're in a very different space now based upon that.
And I think that it's interesting. Well, I had two comments. One, I think it's important to recognize with the Richard Prince and with the Sherry Levine, and I saw in looking through your deck earlier, there's the Jeff Koons stuff that you could talk about. That all three of those artists are really they come up in exactly the same generation. They're New York artists that come up in exactly the same generation in New York, this late 70s, early 80s pictures generation style artists. And so I think that there's such a specific context, and you mentioned Andy Warhol, and of course that's such an immediate aftermath to Andy Warhol, such a specific context emerging in New York at that time that provides the justification for that, and then a certain kind of theoretical basis too, with kind of semiotext, October, kind of post-structuralist thought about the nature of the signifier, all these kinds of things that provide this theoretical groundwork for this aesthetic practices that are happening that then eventually have legal implications and get kind of settled out in these kind of courts of law. And to me, that's such an interesting arc of related issues. So it's like these things aren't in a vacuum or abstract considerations. And I think that ties into what you're saying about these copy-based technological practices as well too. And those are emerging at the same time as we have kind of the emergence of Creative Commons and this idea of sharing and open sharing of information in the early 2000s. And then now here we are 12 years after Creative Commons, 13 years after Creative Commons is released, and we see these wholesale these platforms that have just wholesale absorbed all the value out of the sharing, out of the sharing concept. And so these business practices come in that are just like, see this thing, this kind of spot, and they just like take it. And then turns out there's a ton of value there. Billions and billions and billions of dollars of value is in there.
Yeah, I mean, it also, I think what is perhaps problematic about the circuit court opinion in this particular case is that the court looked at all of the photographs and said that 25 of them were transformative as a matter of law, but then remanded 5 of them for the district court to decide based on the appellate court's reading of what transformative is. And in this case, the court was saying, well, it depends on the perspective of the reasonable viewer. Is that helpful? I mean, who is the reasonable viewer? So it depends on the audience. I mean, it doesn't say what audience. It also talked about the very different markets that Kariu and Prince occupy. In the case of Kariu, he sold $8,000 worth of books. He had never exhibited his works in a gallery, and he didn't sell his individual photographs, although he claimed, and this was never borne out because that didn't go forward in trial, but he claimed that he was going to have a show at a gallery that was very nearby the Gagosian, but the gallerist said that, oh, that's already been done by Gagosian, thinking that Kariu was actually involved in that when he really wasn't. But if you look at some of these works, on the left you see that the court deemed the one on the left transformative as a matter of law, and remanded the ones on the right. And you see there's several examples of these. You can see, okay, and it's not always really clear. Eventually, the parties did settle this case, so this is still the law in at least the Second Circuit. However, there has been some shift in the circuits, and the Seventh Circuit. You can show that one photograph of the mayor. Yeah, this one. In this case, the court looked at this. This is a photograph on the left of the mayor, and this is an image that was created by an artist for a T-shirt. And the court found that this was a parody, and parody can qualify as fair use because it's commenting, and that this was and that it was not the transformative factor that really was decisive in this case. Rather, it was the fourth fair use factor, which was market harm. And in fact, the court criticized the Second Circuit and said that there is not even the word transformative in the four fair use factors, and everything now is based on transformative in so many of the courts. Maybe we should look now at whether this artist is actually usurping the market for the first artist. Anyway, I'm not sure where I was going with that, but that's it. Just a few comments.
But I think that, Judith, to your point, and I'm not going to play moderator because for some reason that's usually what I do on these things. I'm like, that would make me want to talk to Kevin about Monegraph in terms of this idea of market harm and works that are online. So Kevin, can you tell us a little bit about Monegraph?
Sure, I can tell you about Monegraph. Monegraph's a platform. It launches Monday. Everyone can sign up and use it. That is it's really solving just a very small and specific problem. And that is trying to come up with an answer to what is your creativity worth? Is it worth something? And we think that it can be worth something if you can put a price on it. And the way that media has prices put on it is through licensing. So it's a platform to make it really easy for creative people of any kind, anywhere, to set up licenses around the use of their work. And so we have an iPhone app, we have a website where you can have your work, upload it, attach commercial generated usage contracts around if it's an artwork, if it's an editorial image, if it's a commercial image, or if it's a wholesale exchange of the copyright of the work handing over. But these are different template-driven contract, a template-driven contract generation process that gets attached to that image. We use Bitcoin blockchain technology as a way to store that information, the identifiers for the work in question and for the contract in question, so that there's not just a kind of third-party data storage, but because the Bitcoin blockchain allows for transferability, one-way transferability of data. If I have it and I give it to you, I don't have it anymore. Now it's yours, and that's kind of provable in the system that Bitcoin has invented. So we see that as a way of dealing with rights management and licensing. That's the quick version of it. You can share it to social. We make it easier for people to buy it. All these other kind of cool features. But it really is seeing licensing as a way to address this need and make it easy for people. If I was to say to you, how can I license one of your images? You'd be like, I have no idea. And you'd write me an email that said, sure, why don't you go ahead and use it, or something like that. Just happens all the time, every day. That's fine. But just for example, last week or a couple of days ago in the Times, there was an article about brands using social images in advertising campaigns and kind of problematic nature of that. Really difficult to negotiate those things. There's no mechanisms. So, for example, that's a use case that we could solve very easily. And so it's at the level of contracts, and it's not the level of we're not talking about copyright. We're not talking about fair use. Those are a different kind of statutory level or position or whatever, and we're in this other realm of contracts. And so it's not addressing the full scope of practice that's going on, but it's coming up with one way to provide clarity in what is an otherwise very unclear and fraught and confusing world.
I just have one comment there, is that this works when the artist is in agreement with the license. But in these cases, the artist may not have been in agreement with giving a license, but nevertheless, a court would find that this is fair use, or has found that this is fair use. And I also might add that that fair use is very unpredictable. It's really fact driven, and it's very hard to know how a court is going to decide your individual case. So this does offer some certainty to artists who want to borrow works and don't want to run afoul of any copyright problems. So,
I would also say all of these situations the artist wasn't asked. So that's also part of the problem. There's also just how you treat a human, right? Which is you talk to them, you say, hey, can I borrow this thing? Hey, can I use this thing? And you get a lot further. Just throwing that out there, I wasn't asked. But I guess to me, the thing that I keep thinking about is the sort of underlying thing in all of this is like, it's only going to get messier. Right? It's not going to get easier. We are going to just get messier, especially, as Franklin, as you're talking about these copy-reliant technologies. I was trying to remember copy-driven, copy-reliant technologies in which we're constantly sharing economies and all of these new ways of looking at things. And I'm all for Airbnb and all of these other things, which when we're talking about sharing economies, right? But the idea to me that underlies all of this is actually considering artists as humans that need to eat. That to me is like the big underlying thing in all of this, is like, actually, if we could start rethinking the way that we support our artists, then maybe this wouldn't be such a big deal. And I'm all for, like, the crazy commie socialist in me is all for us actually going back to a system or not going back to, but moving to a system in which we value artists within our own communities and support them in ways not only as a community, but maybe from like a federal standpoint. Call me a crazy whatever. In which like healthcare and food and like the basic needs for living are provided for the people that are making a huge amount of our sort of creative content in our lives. And then maybe it's not that big of a deal. Maybe then I'm like, any artist that wants to use my images, like, go for it, mash it up. Right? Maybe then it doesn't become such a problem. So there's part of me that wonders if going down the route of how do we decide whether this is fair use or not is only just digging us deeper into this quagmire of legal questions and culpability and all of these other things. And actually, the other way of looking at it is just saying, like, hey, you're an important artist in our world and we're going to support you. And I struggle with that a lot.
This is going to be the really dry legal comment. But, you know, Walker Evans, one of the things that people always are like, well, how does Sherry Levine get away with that? Exactly. Walker Evans's photographs, by being in the WPA, are actually in the public domain. So you're really kind of describing a situation that did exist at a certain point in time for Walker Evans and a couple of other artists. I don't know that your dreams are going to come true anytime soon. But I think that, in a way, Kevin's proposal gets you part of the way there. And I have one question. Well, I have lots of questions. Who sets the prices? Hello? Who sets the prices?
The artist, the owner of the creator.
Do you have any sense yet of whether that's going to be 15 cents or $1,500 or $15,000 in terms of?
Well, we set $1 as the minimum it could go because of the payment processor. And the payment processor, the maximum they can support is $1 million. So it's going to be somewhere between 1 and 1 million. That's right, because of Stripe. Yeah, 1 to 1 million. That's pretty good, right?
Yeah.
That may change over time, you know, but Stripe, going with Stripe, 1 to 1 million. Perfect.
Do you want to jump in?
I was just going to say, I think actually the funny thing, we had a conference call at one point. One of the things that sort of in my sort of delusional, I understand, but beautiful world in which artists are just like, you know, taken care of and valued highly, is that, you know, I'm all game for any other artist using my work and making good art out of it would be my preferred way. But that if a corporation used any of my work to sell their, you know, like moderately priced and, you know, like cheap clothing line, I would be very angry, right? Because I actually don't want to support that system. So when I talk about this, like if I was going to put my work on Monegraph, what I would say is, if you're a corporation, you're going to pay $500,000 for it. And if you're an artist, you're going to pay $2 for it and prove to me that you're an artist. Do you know what I mean? Like, so that would be like sort of my scale of things, because I really do have a sort of set of values in terms of like how I want it to be used. Not exactly, but sort of a commercial, you know, license to American Eagle would not happen.
And we won't be able, on our first day, we won't be able to support that level of negotiation, but we hope to get there soon to do exactly that kind of thing.
All right, so now I'm going to keep playing moderator and ask Judith a question. So what I hear, which is really interesting, and some of you who, again, maybe copyright fair use nerds, is how this plays into damages and fair use and this concept of bad faith, as well as and how do you arrive at whether somebody gets statutory damages versus actual damages. And years ago, I went to a panel and Roberta Smith was on it with a bunch of lawyers and judges, and they all were just sort of like, we don't understand. Why don't artists just ask each other and license it? And this is so easy, right? We deal with this every day. And with sort of a quiver in her voice, she said, but I don't want to see the world turn into a permission-based culture where artists are expected to go get permission. And I think this is something that we see in a lot of the jurisprudence that is a little bit disturbing, which is that sometimes the courts and, judges are not necessarily the most well-versed in the ways of the art world, and they say, well, this person acted in bad faith because they didn't reach out and ask for permission. And I think it's, on the one hand, so great that particularly for non-fair use instances that something like Monegraph exists. But I have a slightly worrisome side of me that this then makes it even easier for a court to say, but look, there's a system in place for the artist to have gone and asked for permission, so we're going to say not fair use, bad faith, statutory damages. And so, Judith, I know I just gave you a lot to go with.
There are a few issues here. Courts may look at bad faith, and certainly did in the Rogers. Can you show the puppies? In this very famous case, Rogers versus Coons, where the court further back, back. Back even that this case. In this case, the court looked at these two. In this case, Coons, who's been sued several times and finally won a case several years ago, Blanche v. Coons. But in this particular case, he borrowed a photograph of by Rogers of this couple with their 8 adorable puppies, and he created a larger-than-life-size sculpture, the string of puppies, and he was really commenting on banality. And what he did was he sent the card to his workshop in Italy and ripped off the copyright notice and said, make an exact replica. And the court found that this was in bad faith and said that this is not the fair use flag that Coons is flying under, it's the flag of piracy. In subsequent cases, Coons realized that he really had to make some comment and criticism in order to prevail in a copyright infringement suit, and he in a later case, the one with the feet, with the sandals, the feet, and in this case, he took a photograph that was published in a magazine discussing glitter nail polish, maybe, and used that image, turned it upside down, and had it and superimposed 4 pairs of legs on against a background of confections and the Niagara Falls, and this was the idea of overindulgence, and called it Niagara. In this case, the court found that this was fair use, and he used 4 sets of legs, so it was more transformative than previous cases. I also should say that in the intervening years between Rogers versus Coons and Blanche versus Coons, there was the Supreme Court case, Acuff Rose, and that was a case where a rap group, Two Live Crew, did a rap version of Roy Orbison's Pretty Woman song, and the court went through a very lengthy discussion on transformativeness and quoted an article by Judge Laval, who said that Factor 1 is the soul of fair use, and the more transformative a work is, the more likely the fair use is it will stand. So that's how the courts have progressed over the years, and Coons finally did win a case. Now, with respect to your question on statutory damage, this is a very, very good question, because in order to obtain statutory damages, and I think you have a slide on this, the level of damages that you can obtain for a copyright infringement under the copyright statute, you have to have registered your copyright before the infringement takes place. So that's why I would suggest to artists to register their copyright. Yes, they are entitled to copyright protection, but if they want to sue, they will need to register as a prerequisite for filing a lawsuit. If you've registered before the infringement takes place, you can opt for statutory damages. Otherwise, you will have to prove actual damages, and that's not so easy to do. So you would have to prove how much you were actually damaged.
Right. So to sort of play on some of those things a little bit. So first of all, for those of you who don't know, statutory damages is anywhere between $750 and $30,000. But the real kicker is that if the court decides that there was bad faith involved and it was a willful infringement, then they can award damages up to $150,000. And one of the concerns...
Plus attorney's fees to the prevailing party, so the prevailing party will be able to, won't have to pay their attorney's fees. The other side will pay the attorney's fees.
And so, which were expensive. So that can be a lot. But one of the big concerns here then with this whole idea of permission culture, right, is that if you ask permission and somebody says no, well, one, you've alerted them, right? Hey, I plan on using your artwork or your work or what have you. So now they're checking up on you, right? Oh, did you actually use that? Okay, let's say that you went ahead and you sought out Judith or myself, and I said, yeah, you know what, though? It's totally fair use. Go for it. Okay, so now you get sued. And now a court says, actually, we're not going to find fair use. And not only that, you are on notice that this was under copyright. You willfully infringed. And so now there's $150,000 statutory damages plus attorney's fees, right? So the system can be very lopsided. And it's really lopsided because not only do you have to register prior to infringement, but you have to actually register within 3 months of publication. So it's a little bit tighter of a timeline than that. And last night, because I was preparing, bored, procrastinating, I did a little Googling on or I did some record searches on the Copyright Office. How many works do you think Jeff Koons has registered? Like 8. Richard Prince has registered, I don't know, fewer than 10 works. And most of these things are actually catalogs and things like that. But if you look at a sound recording artist, Elton John was like 750. And the thing is that the people who are in industries that have the people who just automatically file with the Copyright Office over and over and over again. So the motion picture industry, they FedEx a copy before anything ever gets released to the Copyright Office. They make their deposit. Publishing houses, commercial photographers. So somebody like an Andrea Blanche's work was most likely filed and registered properly. So if you're an artist Googling around just taking images off the internet, you're actually in a very different situation than if your work is appropriated by a corporation or somebody else, right? So there's the law has an interesting way of putting people on opposite footing.
Because I had always understood that there was a kind of natural copyright. You make something and you have a kind of copyright to it. And so could you describe the distinction between having filed versus a kind of, I'm using that phrase, natural copyright.
I always heard it was the moment that an original work was fixed in a tangible medium.
Good, very
How do I
good.
do it?
I have some of my students here who learned this last week, so and that's terrific. Yes, it has to be.
But also digital files count now. That was like 8 years ago. Digital files counted as tangible medium.
Yes, absolutely. Digital files count as well. So it has to be in a fixed tangible means of expression for more than a transitory duration, and it has to be original, meaning that it's independently created. and then you have copyright protection. A copyright, you have a copyright, but you will still need to register if you want to sue for copyright infringement. But the fair use doctrine is really meant to give breathing room for creative works of art. If artists couldn't borrow from each other, then we wouldn't have all these creative works that I showed on the screen and that we know about. The idea behind fair use is that you don't need to ask permission if it's fair use, because it's implicit in the statute. You are entitled to use it. Well, I should say that it's an affirmative defense against a fair use, against a copyright infringement claim. So if you can prove that you, if you can satisfy a court that with these 4 fair use factors, then a court will grant you fair use. If we didn't have, in the case of Acuff Rose, Two Live Crew did request a license and was rejected. But nevertheless, after going through the court, of course, in the end, Two Live Crew had to pay a license fee. The court in that case found that parody can qualify as fair use, but didn't decide the damages claim. But it did set the stage for analysis in the future with regard to transformativeness. Maybe that's beginning to erode, I don't know, because of the Seventh Circuit, but we're in New York, so it's still transformativeness in New York.
I mean, I would just say, as you're talking, I'm thinking about how the idea of every time I made something to contact the Copyright Office would be crazy. My hard drive has, I think I counted recently, 750,000 plus images on it, which would be just really disturbing. But one of the things that I had thought about when we were talking the other day was that you had mentioned on the Gagosian website there's a really funny sort of thing, which is that, and where did it go? Uh-oh.
Oh, with the Instagram that these are under copyright?
Yeah,
Yes,
it
okay.
actually, so the website says that all images are subject to copyright. Gallery approval must be granted prior to reproduction underneath all of Richard Prince's images,
So
which...
that means you have to ask Gagosian if you can publish your own photograph?
Yes.
Is that what that means?
Yes,
That's
that's certainly what they're saying on there. Not that there's, I mean, it's all over their entire website, granted. And they're, you know, when Hyperallergic approached me, Hyperallergic wrote an article about it, sorry, I didn't mention that. When Hyperallergic approached me about writing the article, they said, but we need an image of the space. Do you happen to have one? Because I'm afraid to pull it from their website because they're so crazy about trying to sue us when we don't ask them first. And I was like, yeah, I took a picture. They didn't stop me from taking a picture. I'll send you the picture I took. And that's what they actually used. And everyone who wrote articles about it after that used the one of mine from Hyperallergic because they were all afraid to use the Gagosian one, which is crazy. Right? It's like the appropriation artist, and you're not allowed to use photographs of the appropriation artist's photographs.
Well, maybe there's a balance. If artists are too fearful of getting sued, they won't use works that they may be entitled really because of fair use to use. And so there's a self-censorship in a sense that is also dangerous, in my view.
And let me just pick up on that, because the piece that I showed was the big video database piece. You know, that was made, you know, we were in complete obscurity at the time of making that, had never sold a work of art at all. And so that, and, you know, I mean, that was an addition. And so the second art sale ever was to the Metropolitan Museum of Art. And so, you know, you just didn't have any kind of concept or, you know, context of where that work was going to be, you know? And then all of a sudden it's just kind of put into this other, you know, it's just like, oh, this is going to cause a problem for us, you know, because we just copied 25 hours of this footage, you know? And we, I mean, there was, you know, we thought about copyright, thought about fair use, thought about the kind of commentary, the kind of transformative commentary we were engaged in, and prepared to well, we talked about that work a lot and certainly described it, but that's different than a court of law, and getting the letter, as you said. And so it does, it does affect you. It absolutely affects you, whether you are subject to an actual action or just kind of thinking about it. It absolutely affects your creative process, your thought process, no question about it.
You also asked, we also discussed in our conference call about other jurisdictions, and we talked about, how this would play out in another court. And Franklin and I were discussing this as well. And I do have a few images of, it's interesting. Fair use is very specific to the United States. So in other jurisdictions, and I'm not an authority on other countries' national laws, but I think it's further up. If you search Belgium, yeah, it's before Richard Prince. Yeah. Even before, yes, that, and even before that, even before that, these are two lawsuits in France that Jeff Koons had a show at the Pompidou Center in Paris, and last year in December there were two lawsuits filed in France. I don't have any information about where these the status of these lawsuits, but you can see that that this photographer created for an ad for NAF, and then this is the work that that Koons created, and then the next one, there was a second lawsuit where he took the photograph of these children and created this sculpture as well, and there's a lawsuit by the estate of this artist, Jean-François Boré. And then this one I think is really very interesting. If you contrast this court ruling in Belgium, an Antwerp court found that this artist had infringed, and that the artist did not agree with the court did not agree with the artist's explanation that this was a parody, because in the court's view, after all, this really wasn't even very funny. So this is a Belgian politician, and this was above, and this is I guess that's one piece. It might be one piece. I'm not sure. I think it is maybe one piece, but in any event, this is how he transformed it. In this type of analysis is very foreign for us. Wouldn't you agree with that? It's not. Yes, based on humor.
I think we're getting close to the end of time. I wanted to open it up to questions, unless you guys had anything else you wanted to add. Here.
Hi, thank you. I feel like you guys have had this whole conversation without mentioning creative copyright, Creative Commons, is that what it's called? I mean, it seems like it's worth talking about that a little bit more, because what I hear you saying is that our copyright laws are broken, and there are people who have been thinking about this who kind of figured out a really good answer. And what are the chances that the laws that we have now could change to accommodate, the difference between commercial reuse, attribution, an attribution requirement? I mean, there are all of these things that are built into Creative Commons, and they fix a lot of these problems. So can't we just fix the laws then?
People are trying. So Lawrence Lessig, who is a Stanford law professor, and he's really the driving force behind Creative Commons. Look, for some people, the copyright law is not broken at all, right? It very much serves their purposes. Those also happen to be corporations that are able to lobby Congress much more effectively. So it's not like that there is a universal sense that this needs to be in some way changed or improved, which is why you have people then choosing to call it either an opt-out or a workaround the current statutory laws that we have, and they'll either do it via contract or via a renunciation of the sort of rights that are automatically granted to them through a Creative Commons license, right? Which again is really a contractual way of changing the law as it exists. There are innumerable working panels. Again, the government moves much slower than technology does. I would, sort of as an aside, electricity, it took 40 years for something like 40% of the US to get electricity. And in 8 years, we have 90% cell phone adoption rate. So when you just think about the pace of technological adoption and change and innovation and how it's accelerating and how in some ways government is decelerating, we're just inevitably at that place where our laws haven't kept up with the new technologies. So people are absolutely thinking about it and thinking about it in a much broader way other than obviously just art and fair use. I mean, we're at Spotify, right? Obviously, digital music has been something that's been driving a lot of the conversation. So it's on legislators' minds. But again, what is the fix? It depends upon your point of view. So.
Just a quick question about Monegraph. What stops someone from licensing someone else's stuff? And how do you deal with that? Is there any protection?
Yeah, so I've got some shares in a bridge that's nearby here that goes from here to Brooklyn, and you could buy them from me, these kind of ownership shares in this Brooklyn Bridge thing. I'm trying to make a dumb joke about the fact that fraud has existed for a long time in many different ways. To answer your question, there's no way you can say, there's no way you can answer that question. It's sort of a metaphysically impossible answer of like, did I take that picture or did you take that picture? Is it mine? Is it yours? It's like, but in a practical way, all you can do is have kind of ask people to say, yes, this is my image, and assert that it's theirs, and have mechanisms in place to try to stop bad actors. So in the case of Monegraph, because it's not just an attribution platform, it's a licensing platform, and you're accepting payments on behalf of that, it's not just a contractual violation, but you're actually committing fraud by selling somebody else's image, right? So you're committing wire fraud. So it's a bigger, you have more at stake in that. And then we have payment records of that, so we can say, well, you just took $100 for this picture, and now it turns out it's somebody else's picture, and there's this record of that, and so you're putting yourself in more jeopardy. So it's a combination of and then we have some technical techniques to kind of stop some kind of cherry pick some easy solutions or whatever. But in the end, it's going to be a kind of hazy range of solutions between some technical things, some legal threats, and some kind of virtuous action.
So if you can't tell whose image it is, like how would this play out in court if someone does this on Monegraph? Is it the same fair use?
I mean, it facilitates the creation of media contracts. So, how you present yourself. So it's like if I go to a real estate closing and I try to pretend that I'm somebody I'm not, I'm defrauding somebody. And so could I get away with it? Maybe yes, maybe no. And so
But in that case, we can verify a person's identity. But in this case, you're saying you can't ever verify the origin of a photograph.
Well, you can. I mean, we have a number of things you can do. I mean, we have the metadata from the photo where it was created. There's a number of forensic techniques you can have that can answer that. But even in forensic cases, like in a strict legal sense, there's open questions about tamperability of an image or whatever. So these are ongoing things. It's not like we have like some magic solutions that solve those things once and for all. And so I think that it's. I don't want to say your question is very relevant, but it's essentially an edge case to the fact that there's a complete missing middle of how can somebody even create a way to you made a photo, how could you even have a commercial conversation about that photo at all? Could you do that? What's the license? How would you get paid? How do you set the terms? How do you get them to file? Can you make that really easy, like 3 clicks easy? Is there a utility in that? We think so. Oh, because they could, yeah. I want to get to a question over here in a second.
Thank you. I feel like contextually, I probably shouldn't bring this up, but just today I was thinking about it. The artist who shall not be named, who has done a lot of work sort of to downplay Spotify's influence. Ryan Adams covered her, and the cover that he produced, the album, which is basically song for song, lyric for lyric, exactly the same as her work on purpose, is on Spotify. And I thought, I wonder if Taylor Swift actually has, if it's in her legal right to ask him to take it off Spotify because she's chosen to not distribute her work in that way. Or if she doesn't, if she has in some way given up rights to control work that is derivative of hers.
I mean, I am far from an expert in music licensing law, and I will defer to you guys if you guys know more about it than I do. But that environment is very complex, and there's distinctions between the performance rights and the music notation rights, the songwriting rights, and I don't know how the deals were made in this particular case, but I imagine that she's not the performer, he's the performer. She's probably the songwriter. And so there's some licensing agreement to the publisher that owns those songwriting credits. But so I don't know, like I say, the details. But there is in music that more complex landscape and a big distinction between the performance and the publishing rights on the sheet music side of things. And this falls into that second case. Is there anybody else?
So in my mind, there's like an absence of language of power in this. So like I have no problem with Richard Prince as a young artist appropriating Marlboro, this big corporation, and I really don't have any problem with him appropriating Cario, who's this white artist appropriating black images and visual and people. So I do have a problem with him taking advantage of Sean's work and without any respect to him. So whereas this, there's not really any language of power in the legal language that I saw at all. So maybe I'm wrong. Yeah, exactly.
This is from you, actually, is the conversation about Cario not being in the same market as Prince. That's actually really troubling because they're talking about power in a way that's not the way that you want to talk about power. It's actually in direct opposition. It's like, well, Richard Prince is this really famous guy. He's not ruining your market because you're not in the market, right? And that, to me, is even more troubling than what you're even proposing, which is this, okay, so all of these comments about, and Richard Prince says the same thing, good artists make great artists steal, or whatever, right? This sort of reoccurring line. And so, and you're seeing it, and I would even argue that what you're talking about when you're talking about, what's my phrase that I'm supposed to use? I'm doing a bad job of remembering it. Copy-reliant technologies. Well, I think so much of what we're talking about right in the internet is actually you're asking the masses, all of us, to make content so that corporations can make money off of us making their content, right? So the question of power in terms of creation and copyright is really at play in this, where we're all getting used as little bots to make stuff so that people look at Failblog, which I think is hilarious. But seriously, it's not like anyone's making any money off Failblog except for the guys that started Failblog. And they also own has Cheeseburger, right? And all of these crazy things that are all user-generated information. And then they're selling all of these ad spaces and making money off you trying to out funny somebody else. That's troubling.
Well, and honestly, that was kind of the crux. That was my thoughts about the comment of Creative Commons then versus now. Not that Creative Commons is off base in any way, but the change in context from the emergence of the sharing economy in 2000 to 2002 versus now, and what sharing means now in the age of Facebook and Instagram and Twitter. Where the billion-dollar platforms, and then you're paid in likes and followers, and maybe you'll get a deal with YouTube if you can get to a couple million people on terms that they set. So just that inability to negotiate real value in the face of kind of social value.
But then there's a little bit of the irony too. It's because like you can also buy the likes and then you can get the popularity, and then other companies will want to use you because you'll be the face because you're so popular. So then that's how other people are making also their living in terms of like whether they're artists or photographers or whatever. So it's like this weird loop again.
So it's all about the attention economy, right? And people will say it's the information economy, it's the creative economy, but really the thing that is scarce these days is your attention. And so that's the thing that actually people are paying for. And so you actually have cumulative advantage as well then, and people have written about winner take all. Music industry is a great example of it, but we see it in the art world as well. So it is interesting that somebody like a Richard Prince is seen as not superseding a Carriou market because he's not a winner. He's not at Gagosian. But in a sort of flip side of it, I'm kind of curious to know, do you think that it's been an overall positive experience? Have you gotten more attention based upon his appropriation?
So this is always, no, this is great. Actually, this is always the question that everyone in the room wants to ask and then is like kind of embarrassed to ask because they think I'm going to be upset about it. And the thing is that, so the work that I made ended up, at the end of it, I really felt like it was so much about this sort of collective authorship. And I started thinking a lot about the creation of memes and who owns the meme and how that happens. And did I own the hashtag? What if somebody invaded my hashtag? Oh my God, why am I thinking about this? Because, you start having these processes going on in your head. And so then, like me, being the person who's like, oh my God, collective authorship, let's start thinking about that in digital spaces. And then that gets appropriated by the person that's supposed to be the death of the author, who becomes the ultimate author, right? Who denies my relationship in that space. And then ultimately, like, the collector shows up and is like, hey, do you want to borrow the piece? So it was like this perfect moment in which all these things came together, and it gave me the opportunity to continue to have the conversation that I was already thinking about on a much larger scale. Now, yeah, it totally worked out for me. I've definitely gotten a lot of attention from the fact that I am the only artist, as far as I know, or up until that point, right, the Suicide Girls did it later, and there was a couple incidents of this later, that had sort of said, like, oh, my comment is, I like playing with strangers. He made his move, now I need to make mine. What's my move? Okay, I'm going to send out a press release and tell everyone to go see my work at Gagosian. Add Gagosian to the group shows on my CV, and like, there we go. This is a great moment in my life. I'm going to use this, right? Up until that point, I don't know of any artists that had responded in that way, as opposed to being upset or suing. So yes, great for me, but also it's about the decisions that you make and how you play the cards that are dealt to you. So.
I think that we should. I think we should end with that.
Yeah. No, I just wanted to thank you all for coming. If you guys have any further questions for our panelists, they'll be available after. And just on a personal note, I was a student of Judith's years ago, not that many years ago, but several. And it was just such an incredible class, and she really got me interested in art law. And I'm so happy that all our panelists were able to come tonight, and we got to learn about Monegraph. And for all of you to know, Monegraph will be launching on Monday. You can try to get on our list. We're going to have a big party, so it's monegraph.com/release party.
At the New Museum.
Yeah, at the New Museum.
That was Roxana. She's one of our volunteers, by the way. So, cool. So thank you so much for coming. Please come up and talk to us or them, anyone you'd like to, afterwards, and stay for a few more drinks. Thanks so much.
Next month, October 15th, is our next meetup. We'll be at Projective one of our future panelists is Kalani, is in our audience. So please mark your calendars. We are covering the artist as entrepreneur. Thanks very much. Have a great night.